You're listening to the Patenting for Inventors podcast, part of the Look Legal Pods from the law firm of Nolan Hyman, the #1 source for your intellectual property, business, and entertainment law needs. Now here's your host, registered patent attorney, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast. My name is Adam Diamond, a registered patent attorney and partner of the law firm of Nolan Hyman in Los Angeles, California. This is episode 143, the new design patent application obviousness test. About 2 months ago, I did a podcast about the possibility that the test for obviousness for design patents might be changing because the full federal circuit was going to be hearing a matter and making a decision. Listen to episode 139 if you want to know the details of that backstory. Now, just for a very quick review, the old standard, it was called the Rosen-Durling test. And that test, it was considered a very rigid test where the examiner had to find one design that was probably pretty close to identical to what you were trying to patent. And that was called the primary reference. And then find some other designs that are called secondary designs or secondary references that had some of the other features, and the secondary designs must clearly suggest their features could be combined with the primary reference. In a rigid test, that means it's harder for the examiner to argue that your design was obvious because they have to find a primary reference that was nearly identical. The Patent Office just put out guidelines last week for design patent examiners for how to examine design patent applications in view of the new case called LKQ Corp v. GM Global Technology Operations. It's not that long, just a 4-page document telling them how their examination should change, and I'm just going to give you a brief summary of it. Now, patent examiners are instructed to use a more flexible, less rigid approach that aligns with how utility applications, those are non-design patent applications, are evaluated. And there's a 4-step inquiry. First, define the scope and content of the prior art. So the examiner doesn't have to find something that's basically the same as the claimed design as long as it's analogous art. I had a whole episode on analogous art in episode 140. Usually it's in the same field, or it should solve the same problem. So if you have a design for a shower head, the examiner should find shower head designs, which would be in the same field. But theoretically, maybe there's a hose sprinkler design, and maybe that's not the same field, but it's analogous. There's going to be some gray areas on what's analogous and what's not. If the primary reference doesn't make the claim design obvious, then the secondary references can be brought in. So that's the first step, defining the scope and content of the prior art. Second, assess the differences between the prior art designs and the claim design. There's not a similarity requirement. What the examiner is going to look for are the differences between the prior art and the claim design. The design examiner is going to compare the visual appearance of the claim design with prior art designs from the perspective of an ordinary designer in the field. Third, determine the level of ordinary skill in the art. This means that you don't try to figure out the differences based on how some random person on the street views it. You have to view it from the knowledge of a designer having ordinary skill who designs articles of the type being examined. So if it's a new phone design, you make the analysis based on people who design phones. If it's a new lamp design, you do the analysis based on an ordinary lamp designer. And if those design changes would be obvious modifications, that's what you're looking for. And the fourth and last step is that the examiner should consider what are called secondary considerations as indicia of obviousness and non-obviousness. Now that's just fancy words for what else is there that might prove that your design is obvious or not obvious. I did a whole episode on secondary considerations in episode 49, but in just one example, let's say that you're selling your new designed product and it's just having, much greater sales than everything out there, and you have lots of reviews that say, I love this new design, so much more attractive than the old design. That's called commercial success. That's evidence that your design is non-obvious, and you can use that with an examiner. If an ordinary designer would have been motivated to modify the prior art design to create the same overall visual appearance as the claim design, then the examiner is going to reject your design application if there are no convincing secondary indicia of non-obviousness. And the examiner is supposed to focus on the visual impression of the claim design as a whole, not on selected individual pieces. When the examiner is taking those secondary references into account, they must be both analogous, and there also must be some reason why an ordinary designer would have modified the primary reference with features from the secondary references. The more different the overall appearance of the primary references versus the second references, the harder it would be for the examiner to make a case that your design is obvious. Now, in the real world, is this going to make much of a difference in design patents? My guess is that using this flexible approach may make some differences in edge cases, but I doubt that it's going to make a huge difference. I've mentioned before that I have never had a design application that I've done get rejected on obviousness. It can get rejected for other things like the drawings weren't done right. My guess is that it might make a bigger difference if you're a company that has a line of products and they're very similar and you keep tweaking little things to get new design patents, then maybe your new designs might be considered obvious over your old designs. But if you're just a solo inventor, you came up with a new design and you didn't copy it off of someone, or you're not deliberately trying to make something look close to another thing, then this test probably isn't going to make that much of a difference. So that's the basics of the new test for design obviousness. The examiner doesn't have to pick a single prior art reference that looks almost identical to your claim design, but the examiner can be more flexible in picking different references that already exist and combining those features as long as there's some rationale to combine those features. Hope you enjoyed this episode, and until next time, I'm Adam Diamond, and keep on inventing.
Thanks for listening to the Patenting for Inventors podcast. If you enjoyed the show, please kindly rate and review on your favorite podcast platform. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information about how we can help with your own legal needs, check out our services at nolanhyman.com. That's NOLANHEIMANN.com. Or call Adam Diamond directly at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.